Okay. Got it. Thanks, Scott.
Okay, aloha, everybody. I think it's 2 o'clock. So I hereby call this meeting of the Reapportionment Committee to order. Secretary, will you please take the roll?
Chair Muguishi,
Yes.
Commissioner Chipchase, Commissioner Chun,
Here.
Commissioner Kennedy,
Here.
Commissioner Nakota. I see your hand raised. Commissioner Nishimura,
Present.
Commissioner Nanaka,
Present.
Commissioner Ono,
Here.
Commissioner Rakpan. I see him there. Chair, you have a quorum.
Thank you, Mr. Secretary. I am going to read the housekeeping item here. Pursuant to the governor's 21st proclamation related to the COVID-19 emergency dated June 7th, 2021, the Reapportionment Commission will be meeting remotely using video and audio technology. This meeting is being recorded and will serve as the official record. The video will be posted on the Office of Elections website at elections.hawaii.gov shortly after the conclusion of this meeting. As a reminder to the public, your microphone will be muted until you are called upon. Okay, so with that housekeeping item taken care of, we'll now move on to public testimony. So first, just a reminder that, whenever you have these virtual calls, technical issues can arise. So we'll give each testifier a few moments to try and resolve them if they do have these problems. If you can't resolve your problems, we'll just have to move on to the next testifier. If you would like to testify, you can click the raise hand button in your Zoom app. And if you're joining by phone, you can press *9, and then the secretary will recognize you when it's your turn. When you are recognized, unmute your microphone before speaking, and please turn on your video at that time. And for the record, please state your first and last name and the item that you're going to testify on. For those joining by phone, we're not going to have your name, so the secretary will identify you by the last 4 digits of your phone number. Commissioners, you'll be muted during the testimony, but you can unmute yourself to ask questions if you have any. Okay, turning it over to you, Mr. Secretary, go ahead.
First testifier is Senator Ocasio.
Aloha, thank you for having me, Chair Mugiishi and members of the commission. I believe you must have received my testimony and the Attorney General's opinion as to two-step process for reapportionment. And I just was asking to clarify, because we're such short in time and wanted to just kind of take some proactive steps because we know that it's going to be coming out late because of the census, and took the liberty to ask them. As far as the opinion, which I'm assuming that you folks have read at this point, that it states fairly clearly that the language within the current Act 14 doesn't affect the two-step process that is outlined in Solomon versus Abercrombie. So I'm just here to voice that and mahalo you folks for looking at that and incorporating that into your process. I'm here for any questions if you folks have.
Thank you, Senator. Any questions for the senator from any of the commissioners? Senator, I think we're in good hands because the Deputy Attorney General that wrote that your review is our attorney as well. So
Wonderful.
yeah.
Oh, so you may already be aware. So that's so wonderful. Thank you so much for giving me the time. I appreciate it.
Mahalo, Senator. Scott, you're on mute.
The next testifier is Sandy Ma.
Good afternoon, Chair and Commissioners. Sandy Ma for Common Cause Hawaii. Mostly we're testifying to make sure that transparency is being observed by this Reapportionment Commission. We want to make sure that the public can fully participate in this reapportionment process. We're concerned about the permitted interaction groups that were formed by the May 17th Reapportionment Commission. We submitted a letter dated June 10th regarding the process. We're concerned that the permitted interaction groups that were formed at the last meeting did not fully comply with the Sunshine Laws. For example, for the Rules Committee that was formed at the last meeting, it was not clear if it was just merely to review and ratify the prior rules or to make adjustments to include the current, to include codes of conduct for commissioners and our staff. And so we're kind of concerned that it did not fully comply with the Sunshine Law. And we're not quite sure that the commissioners understood, all the commissioners understood, according to the Sunshine Law, that there's supposed to be no discussion between the commissioners who are not on the permitted interaction groups, and that recommendations were to be noticed and discussed at one subsequent meeting, and then deliberations and decision making was to be made at another subsequent meeting. So we're not quite sure that things fully complied with the Sunshine Law, and we just want to make sure that the public is fully informed and that the process is transparent. And we provided some sample codes of conducts for the Rules Committee to adopt. So those are our concern. We want to make sure that the public could be fully involved in the process, because there were some concerns at the last Reapportionment Commission that the public was not fully involved. And so we want to make sure that the permitted interaction groups are not used to exclude the public. Thank you very much, and I'm available to answer any questions or concerns. Thank you.
Mahalo, Sandy. And commissioners, any questions for Sandy Ma?
Okay, the next testifier is Becky Gardner.
Aloha, everyone. Can you hear me?
Yes.
Yes, great. Okay. Hi. Yeah, I apologize. I guess I wasn't listed on your testifier list initially. I'd submitted some testimony a couple hours ago, and I just talked to the Office of Elections. They said they found it. Do you have my written testimony in front of you? Does the commission have my written testimony in front of you?
They may or may not. I just forwarded it out to them.
No. Oh, okay. Okay. Well, then maybe I'll be a little bit more detailed in my oral. So I was a staffer for a Big Island legislator back during the 2011 reapportionment process. And during that time, I was tasked with researching the constitutional, legislative, and judicial reapportionment laws. And to me at that time, the very clear mandate wasn't being followed by that 2011 commission. And despite various attempts from multiple organizations and individuals to sort of redirect that commission, the commission went ahead with its process And it later resulted in protracted litigation, both at the state and federal level. And the 2011 Reapportionment Commission was required to redo its plan. And that resulted in a tremendous amount of waste and delay. And I just am watching now just because I want to make sure that doesn't happen this session. And we're dealing with a delay already due to the pandemic and the census data. So I think it's, I just felt a personal responsibility having seen what happened in 2011 that, I started paying attention now just to make sure all the T's are crossed and the I's are dotted. And I think what is really helpful and I know it's a new commission with fresh eyes, and you guys have learned a lot from 2011. So, I'm not here to be like tisk tisk. I'm just here to say, wow, we've got like a really good opportunity to make this really streamlined and accountable. And I think there are 3 resources I want to direct you towards that will help in the process for those who are just getting your hands dirty with it. One is the Solomon v. Abercrombie decision. It was a 2012 decision by the Hawaii Supreme Court. The second would be Federal District Court decision, Cossack v. Nago, which explored sort of the equal protection challenges of what happened with the 2011 reapportionment plan. And then finally, the State of Hawaii 2011 Reapportionment Commission's final report. And in each of those resources, it outlines the 2-step process that is, I think it's Article 4, Section 2 and Section 4 of our state constitution on how to extract non-permanent members. And I'm just particularly concerned about an amendment that was made to HRS 25-2 during this last session, and there had been no substantive changes to the reapportionment process in our statutes since the last reapportionment, except this last session through Act 14. And I believe it was SB 1350. And there was new language that was inserted in a conference draft that put this term only in the way of accounting for non-permanent residents in, in the way that you apportion among the basic island units and then within the basic island units. But the term and the language that was put in the conference draft, the first time it showed up was in conference. And I'm looking at the legislative history and I can't see anything that elucidates what the actual intent of that was. And I think that it's just really confusing. So I'm really glad to see that the Attorney General's issued a letter and that she's also advising, that Deputy AG is advising this commission, because I think the question is put to rest that Solomon still stands, and this new language that's inserted in 25-2, it doesn't seem to have any material effect. In fact, it just kind of muddies the waters. But, of course, everyone understands that the Constitution, it trumps any new laws, especially if it's vague. So the other thing, too, is, I've seen Common Cause's testimony. And I think given what happened in the 2011 reapportionment and the delay and the confusion and the erosion of the public confidence in the process, I would just respectfully ask that this commission err on the side of greater transparency and greater accountability, especially since we're already, delayed due to the census data. And I think that the more open this process is, maybe, above and beyond the Call to Sunshine laws, then we can have, more people engaged and, understanding of the process, and we don't have challenges like we did in 2011. So with that, I'm available for questions, and thank you for the opportunity to provide this testimony.
Mahalo, Becky. Any of the commissioners have questions for Becky?
Oh, I don't. You're frozen, sorry.
Any questions for Becky? No? Okay, mahalo, Becky.
Chair, there are no further testifiers, and I would like to note that Commissioner Chip Chase has now joined the meeting.
Thank you. So let's move on to the next agenda item, which is item 4, which is actually related to the common cause issue that was testified publicly just prior to this. It's an issue that's raised regarding the formation of the permitted interaction groups that we formed at the May 17th meeting. And I was able to consult with our counsel on this matter individually, but I wanted to provide other members of the commission the opportunity to consult and ask questions as well. So I know that at the last commission meeting, we talked about putting executive sessions at the end. But in this case, it doesn't make a lot of sense to talk about the recommendations of the rules committee until we verify for ourselves that we're confident that the permitted interaction group is legal. So I'm going to ask whether or not the commissioners would like to go into executive session to consult with counsel about the permitted interaction group. So if any of you are interested in that, would entertain a motion or discussion about whether or not we go into executive session to consult with our attorney on the question of the permitted interaction group.
I have a question, Mark. I'm sorry. Is it necessary to go into executive session? I mean, wouldn't it just be public knowledge whether we were allowed to do that or not?
Well, I mean, eventually we'll come out with a, what we decide there. But typically, if you're actually asking your attorney for an opinion, you try and do that in attorney-client privilege. That's
Okay.
the way.
Okay.
This is Commissioner Chip Chase. I so move. Second.
Mr. Rathbun, I second.
Okay, there's been a motion and a second. Any further discussion? Okay, if not, all in favor, say aye.
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 Any commissioners opposed? Okay, hearing none. We're going to go in a second into executive session, but before we do that, so that we don't have to keep going back in and out to executive session, we were planning to take up agenda item number 7, members' obligations and compliance with HRS Chapter 84 Standards of Conduct. We are going to take that up at the end. We're going to do that all at once, if that's okay, because that way we can just go in and out of executive session once. So if there is a motion to take up both agenda items in this one executive session, I'll entertain a motion for that.
I'll make a motion.
Second.
I second.
Okay, so we have a motion and a second. Any further discussion?
Chair, this is Lori.
Yes.
I just wanted to clarify that my understanding of the motion. There's been a motion made pursuant to HRS Section 92-5A4 for the commission to convene an executive session to consult with its attorneys on the questions and issues pertaining to the commission's powers, duties, privileges, immunities, and liabilities regarding agenda item 4 and 7. Is that correct? Is that the motion that's being made?
Yes, that is correct. The only clarification is it was made in 2 separate motions, but yes, for both 4 and 7 in compliance with the law.
Okay. Thank you.
Scott, do you want me to call for the vote? Sorry, I wasn't sure if the right protocol is you call for the vote or I call for the vote.
You can, I'll take the vote now.
Okay,
Commissioner Chip Chase,
Aye.
Commissioner Chun,
Aye.
Commissioner Kennedy,
Aye.
Commissioner Nakota. I see your hand up. Commissioner Nishimura,
Aye.
Commissioner Nonaka,
Aye.
Commissioner Ono,
Aye.
Commissioner Rathbun,
Aye.
Chair Mugiishi.
aye.
Okay, the motion carries.
Welcome, everybody. Mr. Secretary, can you please verify that all the commissioners have returned from executive session and are back in open session?
Correct. Everybody is back.
Thank you. Members of the public, thank you very much for your patience. We were able to go into executive session and discuss with our attorney the legality and permissibility of the way the permitted interaction groups were formed at the previous May 17th meeting. All the commissioners are confident that the proceedings were legal and were proper, and that the permitted interaction group formation is legitimate, and that therefore we will entertain on the next agenda item the recommendations of the rules permitted interaction group and discuss those, which are included in everyone's packet and posted on the website, and we'll be able to discuss that for action at a subsequent meeting, because as following the law, we will discuss today and act at a separate meeting. So with that, Mr. Secretary, can you provide a kind of a high-level description of how the Rules Committee took their job and approached making the red line adjustments to the rules?
Okay. So in your packet, as the chair said, there is a red line version of the rules. The committee started with the 2011 rules and made the following changes. They updated references to reflect the 2021 Reapportionment Commission. 2, they updated the commission's contact information. They also streamlined the rules to eliminate any restating of laws and statutes. They clarified public comment procedures. They also amended public hearing notices. The public hearing notice requirement to reflect changes to the law. Number 6, they substituted the term permitted interaction groups for committee to be consistent with statutory terminology. Number 7, they clarified the procedures for permitted interaction groups. And finally, they made typographical non-substantive changes for purposes of clarity. Although there are still some typographical changes, those will be corrected. The typographical non-substantive changes will be made and corrected for the final version, which will be inserted into the packet at the next commission meeting.
Thank you, Mr. Secretary. And just to reiterate that, although the commission now can discuss these draft rules, we can't take action today under HRS section 92-2.5. Permitted interaction groups do not allow the commission to take action on a recommendation at the same meeting at which the recommendation is presented. So with that in mind, I'm now open for discussion of the suggested amendments to the rules by any member of the commission. If none of the other commissioners have a question or comment, I have one actually. I noticed that all the references to the video conferencing or the use of video to have these meetings was eliminated. I just want to ask a question about that because I know that there's a bunch of different laws in effect. There's the existing state statute from 2011 that talks about the conditions under which a video meeting is allowed. And then there's the emergency proclamation that was issued during COVID that suspended all of those requirements and just allowed them to happen. That may go away before this commission is finished with its work. In the meantime, there's a law that's on the governor's desk that I think he's going to sign that establishes new rules for how video conferencing and video meetings can be done, but that may not take effect until January of 2022. And when you put all that together, there might be like a 4-month period where one of those laws is going to be in effect, but it's not clear which one. So I was just wondering if it makes sense for us to put in the rules something that this meeting or commission meetings can be done by video as required by state law, so that it's clear that we will follow whichever law is in effect at that moment in time.
Chair, just to respond to your statement, we did at the Rules Committee have that conversation, and and did seek confirmation and assurance from council that the intent to accommodate for video meetings was allowed for and accommodated in the draft through the references that were provided. But council can correct me if that is not the case, but that's my takeaway from our meetings.
Yes, it would still allow video conference. This is Lori, conferencing as permitted by law. But I think the chair, I understand the chair to be saying he thinks it might be a good idea to have an express reference for video conferencing.
I was just wondering, due to the fact that there's going to be so many, it's like a moving target about which law is actually going to apply. So, I mean, I get it that we're going to comply with the law, but if we so state, it just makes it clear. I'm definitely open to any perspective, though. Like I'm interested what the other commissioners on the Rules Committee might feel.
This is Commissioner Chip Chase. Our sentiment was as Commissioner Chun expressed, just that stating that we're going to follow the law. If we do that for the video conferencing, then we got to do it for every other section on which the law might impact the notice or format of our meeting and those sorts of things. And we didn't want to bog down the rules with those references. Part of the revisions, as you heard Mr. Nago explain, were to streamline it, simplify it, make it clearer by removing a lot of those references. I personally have no objection if the chair would like to add that to the rules and the other commissioners want to, but that's the reason that we didn't include that kind of reference.
Thank you. That makes sense. Is there any other discussion on anything else? I know people have noted that there's a couple of typos in there, and we will
Take care of it.
we'll take care of those, right? So anything else? Well, there being no further discussion.
So Chair, Doc, do you want us to tell the Rules Committee the typographical errors, or how does that happen?
Lori, how would you like to handle the typos? I know I found two, and I know Diane probably seeing the same ones that I saw, but.
I think it's fine if you want to just state it here so everyone can hear.
Okay, so in Rule 7 on page 43, it's in the red line portion. It should be as provided by law. It says as provided by law. That's the fourth line of Rule 7. And then Rule 17, let me see, I gotta get it up here. Rule 17, the secretary shall keep minutes of all ALL, it just says AL, meetings, plural, of the commission. Those are the only ones I saw.
Great. Anything else? Okay, thanks. Hey, I just want to thank the Rules Permitted Interaction Group for their work on this. I think it's a much better document. You know, I remember my English teacher in high school who said every slaughtered syllable is a good deed. And you guys slaughtered a lot of syllables, and this really makes it much clearer, easier to read. And basically the bottom line is we're going to comply with the law. And then that makes it very clear in these rules, that's what we're going to do. So really appreciate all the work that was done there. With that, we'll have it all cleaned up, and so that we can act on it the next time we have a commission meeting. With that, I will move on to agenda item 6. Now, this is a presentation by the reapportionment project staff. And I'm going to turn it over in a second to David Rosenbrock to do this, but I've been told that his presentation is about half an hour long, and we don't have half an hour left. So what I'm going to ask him to do is to introduce himself, say a few words, introduce his staff, and then hold the actual meat of the presentation for the next commission meeting. So maybe, David, what you can do is introduce yourself, maybe explain the role of the vendor and your decision not to hire the GIS analyst. And then we can do the presentation the next time, if that's okay. And with that, I'll turn over to you, David.
David? We'll try it again. Aloha, Commissioners. I am David Rosenbrock, the Reapportionment Commission's project manager. With me today and doing the small presentation is Royce Jones. And he'll be providing reapportionment and district mapping GIS support. Both of us have worked with the previous commissions in 2001 and 2011. We look forward to working with you in 2021. We both have worked with the public, providing access to the same information and mapping resources that you as commissioners have access to. In 2021, as in 2011, the commission and the public will have access to online redistricting resources using an application developed by the mapping software company, ESRI. The commission's project staff also includes Kayag Gier, administrative assistant, and Carolyn Ralden, secretary. The mapping software company, ESRI, in addition to providing the online redistricting application, will be providing other technical support to the commission as shown in the following portion of the presentation, which we'll show you next time. As for the GIS analyst position, given the increased user-friendly nature of the redistricting GIS software that has occurred over the last 20 years, we believe there is no longer a need to fill it. Specifically, in the past, the GIS analysis would provide technical support and produce maps using the GIS system. As an example, in 2011, we used an earlier version of the present software, and members of the public had no significant issues in using it to submit their plans to the commission. Specifically, any issues were straightforward issues that did not require a GIS analyst staff member. Under the present circumstances, we can handle any requests for maps, data, and technical questions with our current staff and existing GIS vendor support. Royce and I will, at the next presentation, will be providing an overview of the two-step process of apportionment and redistricting in Hawaii. We will also cover some additional topics. To begin with, what is reapportionment and redistricting? Why is it done? Who does it? Then we will talk about US Census population data, how it is reported, when we expect delivery, and when it will be available to the commission and the public. We will explain the Hawaii Constitution's requirement in determining two separate population bases. We will then provide information on redistricting guidelines and what should be followed in drawing district boundaries. So that's our mini presentation for today. And I'll
Thank you
take
very
any
much,
short
David.
questions.
Commissioners, any questions for David? Okay. If not, we're going to have to get another commission meeting on the calendar for two reasons, at least. One is to hear the rest of David's presentation, the meat of it, which excited to hear. The second is for us to actually vote and act on the recommendations of the rules permitted interaction group. So Scott's office will be reaching out to you to schedule that next meeting, make sure that we can all attend. And with that, I'll ask first if any commissioner has any further business that they'd like to bring up. If not, I will entertain a motion to adjourn.
I so move.
Second.
Okay. All right, any further discussion on the adjournment?
I'm so sorry. I was trying to unmute myself. Is there any way we already scheduled a backup meeting to this one in case this one got kicked out. Can we maybe agree that could be the next meeting date, just since we already have it scheduled? Does that
Sure, I
work?
think Scott, I think that was your intent, right? So,
That is the intent. So right after this meeting, we're going to send out an invite for that date.
Cool. Thank you.
very good. Okay, any further discussion? Otherwise, all in favor of adjourning, say aye.
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 Any opposed? Thank you very much, everyone. We'll see you soon.
Hi, everybody.
Bye.
Thank you.